This is SJC-13237, Martin Koussa, and others, the Attorney General.
Okay, Attorney Moore.
Good morning, Your Honors, and may it please the court. Patrick Moore on behalf of the plaintiffs. With me in person is Sarah Gross-Nickel. With me virtually is Tom Bean, both of Veril Dana. The framers of Article 48 knew that special interests would use the popular initiative. Their primary goal in drafting that initiative was to make sure that those interests would not misuse it. The relatedness requirement is the mechanism they chose, demanding that each initiative, in the words of this court, present voters with a uniform and coherent statement of public policy. The initiatives at issue in this case plainly fail that requirement for three reasons. First, the purported common purpose here, defining and regulating a contract-based relationship between a company on the one hand and its workers on the other, is an abstraction that could mean anything and will be ripe for future abuse. Second, voters neither understand nor have views on abstractions. Do you want to legalize recreational marijuana and treat it like alcohol? That is a public policy question. Do you want to define and regulate a contract-based relationship? That simply begs further questions. Third,
I have trouble, Mr. Moore, I have trouble with that, that proposition. I mean, we're dealing with gig workers' employment status, whether they're employees or independent contractors. That's something that a lot of the public is more familiar with than probably everyone on this screen, because they are those people. So I don't see why restructuring that relationship is not a uniform, common purpose in our statute. And also our guidance under Article 48 doesn't require complete coherence. It requires some coherence, right? So I have trouble with that part, although I think the tort is different. There I understand. I can see that the public may be in favor of creating this new form of employment status, but the tort seems different, that driver now, I can't sue if they hit me or if they physically assault me. That seems to be a separate proposition. That part I get. Why don't you, do you see a difference there? If we disagree with you on the first part, is the initiative still unrelated because of the second part?
yes, it is, Your Honor. And there were a number of parts to that question. So let me start right there. If the court accepts that a contract-based relationship between company and worker is an appropriate subject for an initiative petition, which it is not, and there are a number of reasons for that, and I will address those in turn. But there are other elements of this proposal that do not, in fact, relate exclusively to the relationship between driver on the one hand and company on the other. One of them is this insertion in the initiative that the drivers will not be considered agents for all purposes under Massachusetts law. That is meant to be a shield from vicarious liability. It has nothing to do with minimum compensation or benefits for the drivers, and it is wildly unpopular. If that were presented to voters alone, it would be rejected out of hand. So what the proponents attempt to do is to put it as part and parcel of their comprehensive scheme that they've offered, hoping that the focus will be on what they emphasize, driver flexibility and freedom, or these benefits, rather than on this shield from tort liability. And that's the classic type of log rolling that this court has rejected in Carney and Anderson and elsewhere. There is another portion of this initiative that also does not relate to the contract.
How do we deal with the AG argues, and I'll be pressing Mr. Boodoo on that because I can't really follow it, but they say, I don't know what it means essentially. And we don't have to decide what it means. And maybe it doesn't mean what it says.
So 2 points to that, Your Honor. The first of which is this court has always taken very seriously what an initiative purports to do. And the Attorney General is assigned with scrutinizing that, both using judicially noticeable facts and also using her own common sense. The proponents certainly do not disavow the idea that they're seeking to avoid vicarious liability. Of course, that's the purpose of the language that's in here. There is a strand in this court's cases that says the Attorney General need not effectively predict the future. Will this operate as the proponents intend it to, particularly in areas that are very ambiguous? Here, there's not any ambiguity at all. Whether or not these drivers are independent contractors does not, under this court's cases, address whether the companies are vicariously liable for them. That is an agency question, whether their acts are imputed to the employer. That's why that language is in here, and it is an impermissible, unrelated purpose. There is, of course, another purpose that goes far beyond a contract.
Is that so odd? I'm trying to make sure I understand that it's not related. So in the past, the distinction between an employee and independent contractor is quite relevant to the agency vicarious liability issue. If this were a conventional employee independent contractor analysis, we would consider it. Now, this whole purpose of the initiative is to transform those two categories. So I understand it becomes different, but is it really unrelated? Because we've historically related those two issues.
This court has said that whether a worker is an independent contractor is a different question from whether the employer is vicariously liable for the acts of that worker.
But it's a related inquiry, don't we? When we do that analysis in cases, we ask that question, don't we?
So that is part of the factors, but it is certainly not determinative. One can be an independent contractor and an agent, and the employer can be vicariously liable for the agent's acts. I would direct this court to the Merrimack College versus KPMG decision of 2018, where this court described agency. Independent contractor deals with the relationship between the worker and the employer. Agency deals with the relationship between the worker and the rest of the world. So sure, are they related at some abstract level? Yes, but that is not enough under this court's cases. I want, though, to question, Justice Kapker, the premise of your question that worker classification is a sufficiently coherent public policy to be presented to the voters. That is not, in fact, so. That is a level of abstraction under which so much fits, it is remarkable. Let's look at everything in this petition. We have compensation. How much should these workers be paid and for what time? We have benefits. The petition relates to health insurance and accident insurance. But of course, it's up to the petitioners whether to cover the field or not. So if that's permissible, the next petition could include, well, we want complete health insurance contributions. We'd like dental insurance and a child care benefit too, and that would all be related. There is tort liability, as Your Honor noted. There's restrictions and conditions of this job and other jobs. So are the drivers required to take certain rides, work certain hours? May they hold other jobs? All under this banner. Eligibility for a social welfare benefit. We have paid family medical leave. The companies cannot contract these workers into that system without changing the law to allow them to do that. They also changed the law on another social insurance benefit administered by the state, which they do silently, but by all purposes, right? An independent contractor for all purposes in the law is the language that they've chosen, and that's unemployment insurance. These also relate to the contracting process. Must the contract be written? How may it be accepted? They relate to discrimination. They purport to provide anti-discrimination protections, of course, that are far less robust than the actual chapters of the general laws that pertain to these issues, but they jam all of these together under the same banner of worker classification. 2 points on that, Your Honor. To link all of these things together is an initiative of a breadth that has never been presented to this court. And a review of all 88 petitions ever presented to the voters will reveal nothing whatsoever like that, because no proponent has ever tried to link. Take this from the other side, right? A raise in the minimum wage, a triple of paid sick leave benefits, a doubling of paid family medical leave. Let's add a child care benefit. Let's make employers strictly liable for the actions of their workers. And let's say all of this controls regardless of any contract, and that all employee rights must be specified daily by electronic notice to each of these drivers. That, according to the proponent's submission to you all, is permissible. They can do that under what Article 48 requires to be a uniform public policy that embodies a singular purpose. That's the language that this court used in Anderson. The initiative must embody a singular purpose. The tell here, Your Honor, it actually comes in 2 places. The first of which is that these initiatives declare these drivers independent contractors and not agents for all purposes under Massachusetts law. Well, what are all of those purposes? And what links them all together other than an employment relationship that is so abstract that basically—
Well, we're not talking about the entire universe of employees. We're talking about drivers in these tech companies, right? Is this really, broader than the legalization of marijuana, where we basically had an initiative that defined the whole industry and all its practices? I mean, we're dealing with tech drivers, right? We're not dealing with all the employees in the Commonwealth. We're dealing with a distinct category, TNC drivers and DNC couriers. Is that what we're dealing with? Sorry.
I believe that's the case, Your Honor. So let me take that at a few levels. The first of which is Article 48 says that if the employment or if the worker company relationship is properly subject to the initiative, how far the proponents go with that is up to them. So they've chosen just to do app-based workers, but they need not be so restricted. Even if they were, though, right? Even if they were and they chose an industry, say nursing, and they decided that all of these things would apply to nurses, that would be awfully difficult to reconcile with Oberle's. You could, in the contract-based relationship, of course, provide a nurse staffing ratio and also demand public reporting on the hospital's financial ability to meet it. But the proponents there did not even attempt that, because linking things together in a contract-based relationship is an abstraction that is so clearly irreconcilable with these cases that it wasn't attempted. Two additional points, Your Honor, and Your Honor mentioned Hensley, and of course that is what the proponents here rely on, saying that you can propose recreational marijuana and you can offer a comprehensive scheme to implement it. And that is true. And the debates demonstrate the difference between a related provision on the one hand with an implementation scheme associated with it and in numerous unrelated provisions, because the initiative drafters had 2 goals, right? One of which was to catapult over the legislature when the legislature wasn't being responsive to public concern. So if you presented the voters with a concrete, digestible public policy question that they understood and approved, you also had to be able to offer them the ability to implement that proposal, because otherwise the voters would have to wait on the legislature. And the entire point of the initiative was that they should not have to do that. And in fact, there's a question about an amendment proposed to Article 48 that immediately follows the relatedness requirement. And there's a lengthy discussion about this. And they say, we need not worry about comprehensive schemes because relatedness will take care of that. What we need to do, though, is to give the voters a way to implement the policy that they've proposed. I see my time is running low. I want to direct the court's attention to two things, if I may. In California, the proponents attempted something very similar to this. California has a single subject rule, but it is a loose rule because it's the same rule that applies to their legislation, right? And the proponents there dispensed with attempting to wrap this all into a single purpose. There are four purposes set forth in the law there, one of which is to make these drivers independent contractors, the second of which is allegedly to give them flexibility on the job, the third of which is to give some type of minimum benefits and compensation, and the fourth of which is to provide some sort of training and security for the people. These initiatives are different in some minor respects, but are almost indistinguishable. The proponents, however, come to you here and say that they only have one purpose. That is the type of an unrelated initiative that all of Article 48 is structured to prevent, and that is why these initiatives should not be certified for the ballot. I thank the court for its time.
Okay, thank you. Attorney Boodoo.
Thank you, Chief Justice Budd. The two initiative petitions at issue in this case propose to create a new worker classification for app-based drivers. If enacted, drivers would be treated not as employees are today and not as independent contractors are today, but instead as a new class, a class unto themselves. Under existing law, there is a binary. Employees are on one side, independent contractors are on the other. Rather than choose sides in that binary, the petitions here propose to do something different altogether.
Right, and why? And I think Attorney Moore's position is that that's just too abstract, right? You're creating this whole new category, you're dumping in all sorts of things, and then you're labeling it as related, even though it really is quite astounding in breadth in terms of this new category of worker. Can you address that?
Of course, Your Honor. This court's case law, including Albano and Hensley in particular, has recognized that a petition may permissibly touch on many subjects, so long as those subjects are related to one another. Hensley, which Justice Kafker mentioned, is, I think, the right analogy here. Hensley, of course, related to a whole host of different subjects: regulation, taxation, licensing, adult use, and more. And this court held that the petition was permissible, that it satisfied the relatedness requirement because all of those subjects still related to the common purpose of legalizing marijuana for adult use. And
here the common purpose is creating a new category of worker. Is that what your position is?
yes, the common purpose is creating and defining the scope of the new classification. And I think this court's misclassification case law has always recognized that a classification by its nature is defined by reference to the rights and obligations that are attached to it. So here, the classification—
I guess I wanted to sort of ask you about that, and I'm sorry to cut you off, counsel, but one of the issues that I think is persuasive is that this initiative is not just defining the relationship and rights and responsibilities as between the worker and the purported employer, but also as between the worker and rest of world. And I guess I'm troubled that something that is that large, let's just say, I agree with you that creating a category of worker is like creating a new marijuana industry. How is this then, impacting the third party's rights? Mm-hmm. How is that related to the relationship between the employer and the worker?
Well, I think, Justice Wentland, it sounds like you're talking about the no agency clause here. And if I have that right, I'll address that. So what I'll say is that we disagree with the plaintiff's interpretation that language would create a so-called liability shield. But even if we are wrong about that, we believe that it would not impair certification under Article 48.
Well, counsel, if you think that they're wrong about that with regard to the liability shield, why wasn't that just said in the petition?
In the petition, Your Honor, or the summary? I'm not sure. Why was that not said?
No, why is that a question mark? Why isn't that clear in the summary?
Well, Your Honor, the summary requires a fair and concise summary of the measure, and not
Right.
legal interpretation and not a legal analysis. The summary here does track the language of the measure. It tracks the provision that states that drivers would be independent contractors and not agents or employees. It does not take a position on what agent means here, because we don't share the plaintiff's interpretation of what that means, and our summaries do not offer legal
But it says
interpretation.
exactly the opposite, and you don't really address it in the brief either. I mean, I can see that the public may feel one way about gig employees and how they're compensated and whether they get all these benefits or not. But the public cares a lot about whether, if they're in an accident with one of those people, are they limited to suing the poor guy who's driving the car, or can they sue the large corporation that can protect them and cover their damages? Those are two different policy questions. And you kind of said, well, without addressing it, as Justice Seibert just said in your summary, and saying you disagree with this provision, but the provision is explicit. It puts the burden of proof on anyone challenging it. It says they're not an employee. Wishing doesn't make it so. I mean, how do we deal with this?
Let me take this in two steps, Justice Kafka, and let me assume first that the plaintiffs are entirely right in their interpretation of what the no agency clause would do here. This court has said time and again, including 2 years ago in Wiener, that we don't evaluate relatedness by reference to effects on existing law. So the key question here,
there's a difference between consequences that aren't expressly stated in the initiative and express provisions of the initiative. I believe we've said the consequences point when we're talking about downstream interpretations that aren't referenced in the initiative. But here we have an express reference with burdens of proof and statements of law, and it's far afield from the rest of the statute, as Justice Wendland just pointed out, which is dealing with the employer or the relationship internally as opposed to externally.
well, I think if we accept that view, then the real nub of the question here is whether the no agency language and the other language Your Honor is referring to is still related to defining and regulating this legal relationship, and we believe that it is. The premise of the plaintiff's argument here is that agency is only about tort. Now, agency relates to tort, but it is also about contract, and it is also about the scope of corporate authority. The language, the no agency language, goes to an agreement that the driver is not invested with the power to speak for the company or to act on behalf of the company. So here, in practice, that might mean that as part of this new legal relationship, drivers aren't, for example, empowered to negotiate their own rates with passengers.
Let's focus on the thing that most people care about, which is if they get hurt by the driver. That's really an important policy question. And it's, I mean, you're going to let the voters vote on this without knowing it. Two, without severing it from they may have totally different views about whether a gig worker should have all these benefits versus whether they can sue the company if there's an accident or a rape. Those are very different issues, aren't they?
The potential consequences could be significant here if the plaintiff's interpretation is right. But what I would say, Your Honor, is this: cases for example, Mazzone, Dunn, Wiener, they have all recognized that there could be consequences, potentially significant consequences to third parties, to the public, but those consequences don't undermine relatedness so long as the provision at issue is still germane to the common purpose. So if we are right here,
But
that
counsel, you have to add something to that, and that is that the public understands what they're voting for.
Mhm. And in our view, Your Honor, the summary here provides the fair and concise summary of the measure that is required by Article 48. It, of course, will be just one piece of what this court has called full information about the proposal. And there is no doubt here that the opponents of the measure will use the 150-word argument that's available to them and the public debate in general to make these arguments about how they interpret the agency clause. I would like to circle back and address why we view this language differently here. And this is why. Because there is always a presumption in statutory interpretation against common law repeal, absent a clear intent to do so. And because the petitions by their terms are limited to the contract-based relationship between drivers and network companies, we view this language as doing exactly the same thing that it would if it appeared in a private consulting agreement or a private independent contractor agreement. In ordinary tort litigation, if the driver and the company had an agreement as between them that said this driver is an independent contractor, not an agent or employee, the court would say that's well and good, and that may be relevant, but the jury will still decide whether there was control sufficient for vicarious liability. Because the petitions here are limited to the contract-based relationship, we view this as doing the same. Even so, we can assume for the sake of argument that we are wrong about that. And the agency provision still relates to the division of authority between the worker and the company. It is here for much the same reason that the same language appears commonly in private independent contractor or consulting agreements.
Ask the voters to vote on it, right? It's no longer a private contract. You're taking it out and you're saying, here, voters, here's this language. We don't know what it means. We, Attorney General, may think one thing, and we're not going to explain it to you. And so I'm sure I'm a little troubled by the analogy to a private contract, because this whole initiative is to take it out of that private contracting sort of default and have the public vote on treating workers as this new classification, as you call it, and having some unknown, unstated, definitely unclear consequences to the general public about which they might care and might have different positions.
It is not uncommon, Justice Wentland, in these cases to have debates at this stage, which is a pre-enactment stage about what language will do. There was uncertainty in Oberle's, there was uncertainty in Abdow, and this court has always been clear that the relatedness analysis doesn't require definitive resolution of these questions. It requires only consideration of whether the provision at issue is germane to the common purpose and operationally related. If I could just touch briefly on the two other pieces of language that were raised today, the any party language and the indirectly language, I will say that we read any party here as a recognition that there are third parties who may be third party beneficiaries in a sense of this petition. For example, family members or spouses who are.
What about why am I, if I'm suing them, why am I not covered? Notwithstanding any general or special law to the contrary, compliance with the provisions of this chapter shall not be interpreted or applied either directly or indirectly in a manner that treats network companies as employers, blankety blank, and any party seeking to establish that a person is not an app-based driver bears the burden of proof. Why isn't that directly on point in a tort suit by someone hurt?
That language, Justice Kafker, I believe, is pulled from the principles of interpretation here. And as with any principle of interpretation, we would not read it as expanding the substantive scope. It also has to be read alongside the first principle of interpretation, the language that comes right before it, that says that the petitions should be interpreted as regulating the relationship between the network companies and the drivers. And the substantive language in section 3, which says that the drivers will be independent contractors, not employees or agents, not for all purposes under current law, for all purposes with respect to his or her relationship with the network company. So that's the basis
It
for.
doesn't cross-reference. Those provisions, the first provision you cite says it's for all purposes with respect to his or her relationship with the network company, meaning it's point blank. And then we've got this other provision, which is dealing with other parties. And it's making a statement about other parties. It clearly goes beyond the first one, which is dealing just with the internal, doesn't it? I mean, again, this will be subject to litigation, but the public, none of whom, have, they're not trained in this fine level of distinction either. And they're, and they're certainly going to be bombarded with ads that say this, and then they're not going to have any guidance from the AG's office what the answer is. But we'll see. I'm curious whether the interveners are saying that's not what they mean and they're publicly going to announce that. I suspect that's not the case, but we'll hear.
Let's hear.
I thank the court for its time. I would urge the court to affirm the Attorney General's certification decision.
Okay, thank you. Attorney Hewer.
Good morning, Chief Justice Biden. May it please the court. Tad Hewer on behalf of the interveners. With me virtually are Andy London and Seth Reiner. I certainly have something I've prepared to say, but I believe there are questions that are going to be directed at me that may take up my time. I would open only by saying this. When you take a job, you want to know a few things. You want to know what your responsibilities are. You want to know what authority you have or don't have, as the case may be. You want to know what benefits you'll get, and you want to know what you're going to get paid. These things are all intuitively related. And that's what this petition articulates in the company driver context. As the Attorney General has mentioned, this relationship will be neither classic independent contractor nor classic employee. It's designed for the gig economy, and it's eminently appropriate, indeed, we would say arguably essential, for such a new law to state its key parameters and anticipate and address the foreseeable consequences of making this classification.
So, Mr. Hewer, I agree with your first part. Now let's get to the torts. What does this mean to your clients? Are they saying they agree with the AG that this has no, this only applies to the internal and the parties are not? Parties aren't those of us who are out in the car with our Uber driver or our Lyft driver and get hit in an accident, or who? What does that mean?
Sure. So there are a couple of elements here. There's the tort issue, which relates to agency, and then there's this stuff we just discussed previously at the end of the discussion about any party and directly or indirectly. I'm happy to speak to all four of those, and I think it'll be valuable for the court. On the tort question, first of all, I think our position is that drivers are already not agents. They're currently independent contractors. So in some sense, it doesn't change anything. It's declaring what we believe is already the case. That being said, of course, the initiative, by definition, by saying that the drivers are not agents, eliminates any claim that's based solely on an agency theory. And again, that's not just tort, but that's negligence.
So you're clarifying the law and saying, if there's any doubt about whether that driver will impose liability on, the parent company, however we want to describe them, this is eliminating that.
Does that come solely through an agency claim? If the answer is yes, then the answer must be yes, because
so you disagree with the AG's interpretation of what that language means. You have a fundamental disagreement, and you believe it provides tort protection.
I don't think we have a fundamental disagreement with the Attorney General. We're merely saying that if someone is not an agent, you can't bring a claim based on an agency relationship. That's not saying anything unusual at all. That happens every day in the courts of the Commonwealth. The key thing here, I think, is two. One, that what seems to be animating this, and certainly you've raised this concern yourself, is what happens to an injured individual? Are they left somehow without recourse if this petition passes? And the answer is absolutely no. We know that because Chapter 159A.5, which is the current network company statute, establishes a $1 million insurance requirement per driver to be paid by the transportation network companies. Chapter 175, section 228 contains additional insurance requirements. That's on the insurance side. Drivers are already licensed and regulated by the Department of Public Utilities. They have their own entire subdivision at the DPU that runs background checks and makes sure that these drivers are appropriately classified. And
So counsel, you're saying that the rules regarding the employers purchasing liability insurance for the employees would stay in place?
we will not say they're employers or employees, but yes.
Well, I'm just, I know what you mean.
I think the other element here is on this notion of agency, because we need to know, is it related or not? And the issue about relationship is key, because that's the Article 48 test. And to say that you have no relationship to defining a contractual relationship about agency, agency is a relationship between an agent and a principal. It's hard to see what could not be related to a common purpose of defining a legal relationship between one party who could be a principal and another party who might not be, about whether or not that person is or is not an agent. I mean, that's what the Mack Trucks case says.
So again, tort liability is not defining tort liability here is part of this proposal. You began by limiting, look, the contractual relationship and all these different elements, but you're also saying, and tort liability to outsiders is part of that relationship.
It may have a consequence in the exact same way it does in Abdel, right? All we're saying in this law is that it clarifies in black and white that there is no mutual consent to form a company driver agency relationship. That's entirely permissible. We do that all the time. The real question here is whether that's related. And we would say, yes, it's part and parcel of this relationship. In Abdel, we had a situation where—
So you think when the voter, again, because we're dealing with voters, you think the voter looks at these as related, whether this contractual employment relationship and whether who they can sue and how much exposure, you think those are related in the public's mind, even without anything being mentioned in the summary. That's all related. They understand these things are related.
I think every voter who has a job or knows someone with a job knows that you're asking those fundamental questions I articulated at the outset. What are your responsibilities? What are your obligations? What do you get paid? And what are your benefits? If something relates to
what
that—
are your liabilities to third parties? Whether you think the average Joe understands what his or her responsibilities are to, in the event of an accident, and whether they're on the hook by themselves or whether the company is on the hook.
I think it's frequently made in all types of situations. Everyone can read a newspaper. They know that there are accidents that happen all the time. You know, if you're an employee, that your employer says, I've got insurance coverage for you. Don't worry if you're out there driving. Those employees turn themselves into riders and users of these services. I think people are well aware out there that there are legal regimes that say whether or not you're covered or not covered, when you can represent yourself as speaking for someone or not for someone. And again, this goes, this notion of agencies goes just beyond this notion of tort, which again, doesn't appear at all in the petition. This is a gloss that's being put on by the plaintiffs and apparently, to some effect. All we're talking about here is a situation where you don't have agency. And if you are, for instance, a driver who walks into a mechanic's shop and you drive for any one of these network companies and you say, do the tune-up, charge the company for it. And the mechanic says, great, you've held yourself out as an Uber driver. So I'll send the bill to Uber. Uber writes back and says, sorry, that's not us. It's pretty important to let that employee know at the outset that they can't just go in and run up a bill on the company's dime. They're an independent contractor. They're not an agent. They can't go and represent themselves as being one. On the point about any party, because I think it's something that was raised at the end of this, the plaintiffs seem to forget sometimes that we're defining the default terms of a bilateral contractual relationship. That's the express title of the petition here. And in a bilateral contractual relationship, the word party refers to both parties, right? The company and the driver. And here the plaintiffs keep saying you should have just said driver if you meant driver. We didn't just mean driver. We were talking about a contractual relationship between parties. Under the proposed law, not every driver is an app-based driver. That's clear from the definitions. For instance, a delivery driver who's engaged in residential moving services isn't an app-based driver. So let's say you have a situation in this clause, section 11, where an individual claims to be an app-based driver and the company disagrees. Under this section, the company, that's the party, bears the burden of proof to show otherwise. Right? Conversely, the driver asserts that they're not an app-based driver. They think they should be classified as an employee for whatever reason. The driver then bears the burden of proof. Using the word party is entirely consistent with defining the company-worker relationship in this very context. And once again, just like in ABDAL, where we had a redefinition of the term of illegal gambling, and the petitioner said, well, or the opponent said, we've got a problem here because that could have downstream effects on whether or not you get evicted from public housing, right? Because there was a provision in the public housing law that says you can't engage in illegal gambling. And the court said, that's not for us to look at. The court says they reject the intervener's argument that the subjects aren't related because it would change the definition of illegal gambling and have consequences under an assortment of other statutes. And the court repeatedly held there and elsewhere that if there is such a downstream impact, it doesn't bear on the Article 48 relatedness issue. As long as these things are all related to each other, those impacts can be understandable and can be had, and they can be hashed out later. But here on this notion of what a party means, it is very easily determined as something that's inherent and central to that contract or the contract relationship between the worker on one hand and the company on the other.